Why is hearsay used as a fact or to establish facts in family court that goes on the record and can be used as a false representation of the character of the respondent or other things? Great question. Hearsay is defined in legal terms as testimony that is given by a witness who relates not what he or she knows personally, but what others have said or purportedly said, and that is therefore dependent on the credibility of someone other than the witness himself or herself. Such testimony is generally inadmissible under the rules of evidence. Hearsay is a statement, either verbal or nonverbal assertive conduct, other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Also termed hearsay evidence or second-hand evidence. You can see the definition in Black's Law Dictionary, 11th edition, 2019. Many people who are not lawyers or not well informed about legal principles have perhaps heard or read that hearsay is never admissible as evidence. This is not true. Some hearsay is admissible under certain circumstances, and there are other instances of what might first appear to be hearsay or that would be hearsay but for characteristics that make them exceptions to the rule that hearsay is inadmissible evidence. That stated, I hear you. Inadmissible hearsay is far, far too often considered by judges who know better, especially, though not exclusively, in divorce and family law cases. Why is that? In my professional opinion, the reasons include 1. When judges believe they have developed an ability to discern whether hearsay statements are in fact true. 2. When judges don't want to spend the time or make the effort associated with obtaining evidence the proper way, accepting hearsay as a shortcut. When judges want to avail themselves of the convenience of accepting hearsay evidence, in other words. When judges think, that story's pretty convincing. It feels true, so odds are that it is, I'll accept it. 3. When judges need to admit, quote unquote, the hearsay evidence so that they can justify a particular ruling they want to make but cannot make without the hearsay evidence as the basis or as part of the basis of the findings of fact and conclusions of law underlying that desired ruling. 4. When judges either honestly believe there is some kind of exception for admitting hearsay statements attributed to children, or find that such an exception exists to shield the child from having to testify for himself or herself. Now, I practice law in Utah. To learn more about hearsay in depth, including exceptions and exclusions regarding the hearsay rule, I have provided links to the Utah Rules of Evidence in the description section of this video.